This is the Study for the Bar in Your Car podcast.
Woo! Welcome back.
We're your hosts, Maud and Claude.
And today we're tackling episode 15, Torts, Negligence Part 4, Causation and Proximate Cause.
That's right. Now you know us, we are AI bots.
Yep, brought to life by the magic of AI and, of course, Angela's fantastic negligence notes.
Angela isn't with us today, though. She's actually prepping for the bar exam right now in the Marshall Islands.
Wow, the Marshall Islands. That's definitely an exotic study location. Very cool.
Right. She graduated from George Mason University, and she really is the brains behind this whole operation. The architect, you could say.
Absolutely. Her notes are the foundation for everything we talk about here. Really sharp analysis.
They are. And if you need to get in touch with Angela, maybe about the podcast, you can email her at podcast@studyforthebarinyourcar.com.
And just a reminder, Angela also works as a freelance law clerk. So, if you're an attorney or maybe you know one who needs a hand with things like legal research or writing motions.
Or even getting up to speed with AI in their law firm.
Exactly. You can reach out to her for that professional work at hello@legalwriterandlawclerk.com. She's great with both legal writing and, AI stuff.
Okay, so let's dive into today's topic. We're really going deep on causation and proximate cause. These are just absolutely critical elements in any negligence claim.
Crucial. But it's not enough to just show someone was careless, right? You have to prove their carelessness actually caused the harm.
And not just that, but also that they should be held legally responsible for that specific harm. It's often where the real fight happens in tort cases.
It really is. We're going to unhack the difference between actual cause, that's the did it happen because of this part, and proximate cause, which is more like, should they be legally on the hook for this?
We'll look at the tests courts use, like the but-for test.
And the substantial factor test for those trickier situations. Expect some aha moments, hopefully, as we figure out how the law draws that line for liability. It's all about fairness and, importantly, foreseeability.
All right, my circuits are buzzing. Let's get into it. Causation. We need both actual cause, sometimes called cause in fact, and proximate cause, or legal cause. You need both, period.
That's the starting point. Both are essential. Let's nail down proximate cause first. It's not just about a chain reaction. It's really a policy tool, a way to limit liability.
Limit liability? How so?
Well, proximate cause or legal cause, scope of liability, whatever you want to call it, basically asks, is the defendant's action sufficiently related to the harm to justify making them pay? Think about it. Without this idea, one little slip-up could lead to liability for, practically anything that follows, no matter how weird or far-fetched.
Okay, so it's like a legal brake pedal. Stops liability from spiraling out of control. It feels like fairness baked into the logic.
That's a great way to put it. It prevents absurd results. So if proximate cause is that legal boundary, how's it different from actual cause or cause in fact? That sounds more straightforward.
Yeah, because in fact sounds like just fact.
It mostly is. Actual causation is purely factual. Did the defendant's negligence actually lead to the injury? The main test here is asking, would the injury have occurred without what the defendant did wrong? It's about that direct physical link.
Okay.
Proximate cause, though, it steps back. It asks, okay, maybe they caused it factually, but should they be held legally responsible for this specific harm, given how it happened? It brings in things like foreseeability and, public policy.
Yeah.
Is it fair to hold them liable here?
Gotcha. So, actual cause. Did you light the fuse? Proximate cause. Should you pay for the fireworks display, even the unexpected parts? And you need both. Can't have one without the other for a successful claim.
Affirmative. Both links in the chain have to hold. And for that first link, actual cause, courts have a couple of key tests they rely on.
Starting with the big one, the but-for test. This seems to be the main workhorse. The idea is the injury would have happened but for the defendant's breach of duty. Simple, right? Sometimes.
It's the default, absolutely. Pretty intuitive. Let's take an example. Say a driver is speeding doing 57 in a 50 zone. That's negligence, per se, right?
Yeah.
Breaking a safety rule.
Right.
Okay, so they hit a pedestrian. To prove actual cause using the but-for test, the pedestrian has to show that their injury, or maybe how bad it was, would not have occurred if the driver had just been going 50.
So maybe at 50, they could have stopped. Or the hit wouldn't have been as bad.
Exactly. Maybe just scrapes instead of broken bones. And importantly, even if there were other potential causes floating around, maybe the pedestrian wasn't paying attention. That doesn't automatically let the speeding driver off the hook. If the speeding was a necessary condition for this injury to happen, That's enough for causation against the driver.
Okay, that makes sense for straightforward cause and effect. But what if it's messier, like multiple things happening, maybe multiple people being careless? Does but for still work then? It feels like it might break down.
You're onto something. It can break down. And that's precisely why we have the substantial factor test. It's designed for those situations where but for fails, usually because you have multiple causes combining to create one single indivisible injury.
Like situations where you can't honestly say that but for any one person's negligence, the harm wouldn't have happened.
Exactly. The classic example everyone learns is the two-fire scenario. Imagine two people acting totally independently, negligently, start fires on their own properties.
Okay.
These two fires then merge, becoming one big fire, and burn down the plaintiff's barn. Just one barn. Now, try applying the but-for test to fire starter A.
Well, but for fire A, would the barn have burned down? Yes, because fire B was coming anyway.
Precisely. And the same logic applies if you look at fire starter B. But for fire B, the barn still burns because of fire A. So under a strict but-for test, neither one is liable.
Which seems crazy. Two negligent people burn down a barn and neither pays.
Exactly. It's an unjust result.
Yeah.
So the substantial factor test steps in. It asks, was each defendant's negligent conduct a substantial factor in bringing about the harm? If yes, they can both be held liable.
Ah, okay. So it looks at whether their action contributed significantly, even if it wasn't the only thing that could have caused it?
Right. It works even if they didn't coordinate, or even if neither fire alone would have been enough. If their negligence was a substantial element in the final result, they're potentially on the hook. There are real cases like this involving merging fires or other combined causes, like that combined transport case involving spilled glass. The spill wasn't the sole but-for cause, but it was definitely a substantial factor in the death that occurred.
That feels much more realistic. It handles situations where multiple factors converge.
It does. And there's one more wrinkle in actual causation, though it's rare: unascertainable causes, sometimes called alternative liability.
Unascertainable. Like, we know someone was negligent, but we just can't tell who.
Pretty much. Imagine two hunters negligently shoot in the direction of the plaintiff at roughly the same time. The plaintiff gets hit by one shot, but there's absolutely no way to tell whose gun fired the harmful pellet. Both were negligent, but only one caused the injury.
Oh, wow. So under but for, the plaintiff loses because they can't prove which hunter's shot caused the harm.
That would be the standard outcome, yes. But the law sometimes makes an exception here. In these rare cases, the court might actually shift the burden of proof.
Shift it to who?
To the negligent defendants. Instead of the plaintiff proving who did it, each defendant has to prove they didn't do it.
Whoa. So prove your innocence or you're both potentially liable.
Essentially, yes.
Yeah.
If neither can prove they weren't the cause, they might both be held liable, often jointly and severally. The famous case is Summers v. Tice with the hunters. The idea is it's effective to hold both negligent actors responsible than to leave the clearly injured plaintiff with no remedy, especially when the defendant's negligence created the very uncertainty about causation.
That's a powerful move by the courts. It really underscores that the goal is often to compensate the victim when there's clear wrongdoing, even if the evidence gets tricky.
Exactly. And you sometimes see similar ideas in, say, market share liability for defective products, like a bad drug made identically by several companies. If you can't tell which company made the pill that hurt you, some courts might assign liability based on their share of the market, unless a company can prove its product wasn't involved. Very specific, but it shows the law adapting.
Okay, so that covers the did it actually happen because of them? The cause, in fact. Now, let's pivot back to the other essential piece. Proximate cause. This is where the policy and foreseeability really come in, right? It's less about the if and more about the should.
Precisely. Proximate cause is where the law draws a line, saying, okay, even if you factually caused this harm, it's too remote, too indirect, or too unforeseeable for us to hold you legally responsible. It's that policy-driven limitation we talked about.
The legal brake pedal again?
Yep. It prevents liability from extending to every single ripple effect, no matter how distant. It asks if the defendant's conduct is sufficiently related to the harm to justify imposing liability.
And the key factor in determining if it's sufficiently related is foreseeability.
Foreseeability is the absolute heart of proximate cause. The main question becomes, was the type of harm that occurred a reasonably foreseeable result of the defendant's negligent act, or did the defendant's conduct foreseeably increase the risk that some intervening force would cause harm?
So it's not about predicting the exact crazy chain of events.
No, not at all. It's about whether this kind of harm was within the scope of the risks created by the defendant's negligence. Could a reasonable person foresee that acting carelessly in this way might lead to, generally speaking, this sort of outcome?
Okay, focusing on the type of harm. And just to hammer it home, we need both actual cause and proximate cause. Still a two-part test.
Always non-negotiable. The defendant's action must be a but-for or substantial factor cause, and the harm must be sufficiently related in terms of foreseeability and policy. That defines the scope of liability. You can't skip a step.
That brings us perfectly to intervening and superseding forces. This is where things that happen after the defendant's negligence can really complicate the picture. Sometimes they break the chain of responsibility, sometimes they don't.
Exactly. It's crucial to understand that not every event that happens between the defendant's negligence and the final injury will automatically cut off liability. Some intervening forces are considered foreseeable.
Foreseeable, like things you'd reasonably expect might happen as a result of the initial negligence.
Precisely. If an intervening force is considered a normal or foreseeable consequence of the situation the defendant created, then it's not a superseding cause. The original defendant remains liable for the ultimate harm, even if that intervening force contributed.
Okay, can you give us some common examples? This seems like prime bar exam territory.
Oh, absolutely. First big one. Negligent medical treatment. If I negligently injure you and you have to go to the hospital and then the doctor commits malpractice and makes your injury worse.
I can still sue you, the original negligent person, for the worsened injury.
Yes. Medical malpractice following an injury is generally seen as a foreseeable risk. You needed medical care because of the initial negligence, and unfortunately, things can sometimes go wrong during treatment. That risk is considered part of the scope of the original liability.
Wow, okay, what else?
Second common one, negligent rescue attempts. If my negligence creates a dangerous situation, like a fire or someone dangling from a ledge, it's foreseeable that someone might try to rescue the person in danger.
The danger invites rescue idea?
Exactly. And if that rescuer may be trying their best but acting a bit carelessly accidentally makes things worse or gets injured themselves, the original negligent party who created the danger can still be held liable for that outcome too. It's foreseeable that rescue attempts might happen and might not be perfectly executed.
So, creating the danger makes you responsible for the foreseeable consequences of trying to fix it. Makes sense. Any others?
Yes, a third key category is subsequent accidents caused by a weakened condition. Let's say you're injured in a car accident because of my negligence. Maybe you get a bad back injury that makes you unsteady on your feet.
Okay.
A few weeks later, because your back is weak and you're unsteady, you fall down some stairs and break your arm. That fall and the broken arm can be considered a foreseeable consequence of the original back injury. The original tortfeasor can be liable for the broken arm too, because the weakened state that led to the fall was a direct result of their initial negligence.
So, the rule seems to be, if the intervening event is something you could reasonably see happening as a result of the initial mess-up, like needing medical care, someone trying a rescue, or being more vulnerable to further injury, the original person stays on the hook.
That's the general principle for foreseeable intervening forces. They don't break the chain.
But some things do break the chain, right? What makes an intervening force a superseding cause? The kind that lets the original defendant off the hook.
Right. A superseding cause is something different. It's an intervening force that is so unexpected, so far outside the scope of reasonable foreseeability, that the law says it's unfair to hold the original defendant responsible anymore. It has to be something truly.
What?
Well, the terms often used are freakish, bizarre, highly culpable, or extraordinary.
That sounds incredibly subjective. How do courts decide what counts as freakish or bizarre?
It is highly fact-dependent, which is why it's almost always a question for the jury. They have to decide if the intervening event was so out of left field that it essentially overwhelmed the original negligence as the cause.
Is there a classic case that illustrates this?
The classic one is often Watson v. Kentucky and Indiana Bridge and Railroad King. Remember that one? The railroad negligently spilled a massive amount of gasoline from a derailed tanker car.
Yeah, you mentioned it. Foreseeable harm. Fire.
Exactly. A fire did happen.
Yeah.
But how it happened was the issue. A man named Durr, apparently known for being malicious, intentionally threw a lit match into the pool of gasoline.
Whoa, intentionally, not just carelessly dropping a cigarette.
That was the key question. The railroad argued that Durr's deliberate criminal act of arson was so unforeseeable and culpable that it should be a superseding cause, cutting off their liability. Even though fire itself was foreseeable from spilled gasoline, a third party intentionally starting it was argued to be outside the scope of risks the railroad should have anticipated.
So the manner in which the foreseeable harm occurred was potentially unforeseeable.
Precisely. The court essentially said if Durr just carelessly dropped a match, maybe the railroad is still liable. But if he acted maliciously, that intentional bizarre act could supersede their negligence. It highlights how a third party's independent, highly culpable, or truly extraordinary act can sometimes sever that proximate cause link.
That really clarifies how proximate cause acts as that fairness filter. It's looking at the whole picture, not just the initial act.
Okay, this is super helpful. Let's shift gears slightly to some special considerations and definitely some bar exam strategy. First off, that rule with the funny name, the eggshell plaintiff rule.
Ah, yes, the eggshell plaintiff, or sometimes thin skull plaintiff rule. It's vital. And it often feels counterintuitive when you first learn about foreseeability.
So what's the rule?
The rule is the defendant takes the plaintiff as they find them. What this means is, if the type of harm is foreseeable from the defendant's negligence, the defendant is liable for the full extent of the harm caused, even if the extent was totally unforeseeable because the plaintiff had some hidden vulnerability or pre-existing condition.
Okay, unpack that. If I negligently cause a minor fender bender, maybe just a tap.
Right, foreseeably causing maybe some minor whiplash or scratches. But the person I hit has, say, a rare condition that makes their bones incredibly brittle, and the minor tap causes them to suffer multiple severe fractures. I'm liable for all those fractures, even though I couldn't possibly have known or foreseen that vulnerability.
Yes, exactly. You foresaw the type of harm, physical impact, potential injury. The fact that the extent of the injury was way beyond what you'd normally expect doesn't matter. You are liable for the actual damage you caused to that specific person.
Wow. So the foreseeability limit applies to the type of harm, not the extent of harm, when it comes to the plaintiff's condition.
Correct. The policy is that the wrongdoer, the negligent defendant, should bear the cost of the harm they actually inflicted, rather than the innocent, vulnerable plaintiff bearing it just because they were unusually susceptible.
That's a huge point. Very important distinction. Now, we touched on this, but who decides if proximate cause exists? Judge or jury?
Generally, it's a question of fact for the jury. Because foreseeability, whether an intervening cause was truly bizarre, these often involve judgment calls that reasonable people could differ on. The jury gets to make that call based on the evidence and community standards.
So it's usually in the jury's hands. When would a judge decide it?
Only in rare cases where the fact's completely undisputed and so clear-cut that no reasonable person could possibly disagree about whether proximate cause exists or not. If there's any room for debate, any way reasonable minds could differ, it goes to the jury. That's why summary judgment on negligence issues, especially proximate cause, is often hard to get.
Okay, that makes sense. It's often fuzzy. So let's quickly recap those three main categories where proximate cause gets tricky due to unforeseeability, just to lock it in.
Good idea. The three main areas are, 1, an unforeseeable type of harm. Your negligence foreseeably risks property damage, but somehow causes, say, purely economic loss to someone uninvolved. That type might be unforeseeable. 2, an unforeseeable extent of harm. This is where the eggshell plaintiff rule usually applies, making the defendant liable anyway. And 3, an unforeseeable manner in which the harm occurred. That's the Watson situation, foreseeable harm, fire. Happens in a totally bizarre or unforeseeable way. Intentional arson. Getting these straight is key.
Type, extent, usually covered by eggshell rule, and manner. Got it. So, the million-dollar question. Bar exam strategy for proximate cause. How should listeners approach these questions under pressure?
Okay, practical advice time. On the bar exam, especially multiple choice, here's the general approach. Unless the facts given to you explicitly describe an intervening event that is clearly, undeniably weird, bizarre, criminal, intentional by a third party, or otherwise screams superseding cause.
Like aliens landing and causing the final injury.
Yeah, something like that. Unless it's really laid out as extraordinary, you should generally assume that proximate cause is satisfied. Don't invent superseding causes if the facts don't strongly support it. The examiners usually test the basic rules, not the most obscure edge cases, unless they give you clear signals.
That's reassuring. So lean towards finding proximate cause unless the facts actively push you away.
Pretty much. And one more related tip. For negligence per se questions where someone violated a statute.
Like speeding.
Right. Remember, proving the statute violation only establishes duty and breach. You still have to separately prove that the violation was the actual cause, but for or substantial factor, and the proximate cause of the specific harm that occurred. The violation doesn't automatically equal causation.
Got it. So negligence per se gets you partway there, but you still need to connect the dots with causation and proximate cause analysis. Excellent advice. Look for those explicit superseding facts, otherwise assume the chain holds.
That's the safe bet for the bar.
Phew. We have navigated the twists and turns of causation and proximate cause. It's complex, but hopefully breaking it down makes it feel more manageable. It's so fundamental to negligence.
It really is, and we absolutely have to end by saying a huge thank you to Angela. Her torts notes are just invaluable for these discussions. They make these complex topics so much clearer.
Couldn't agree more. Thank you, Angela. Okay, before we sign off, just a few important bits of housekeeping and the usual disclaimers for you all. First, please remember, Angela is a student, just like many of you listening.
Right. She's not an expert in the professional sense, and she hasn't passed the bar yet. She's sharing her learning journey.
Which means, point 2. Angela, and by extension, this podcast, we are not giving legal advice. Seriously, nothing we say should be taken as legal advice.
Absolutely not. And AI, while helpful, is no substitute for digging into the law books and cases yourself. Use this as a tool, not your only source.
Definitely. This podcast should supplement your studies, help things click, but please don't rely on it as your only way of preparing for the bar.
And, AI isn't perfect. Sometimes we might make a mistake or misinterpret something.
It happens. Angela does her best to review everything and catch errors, but perfection is tricky, even for algorithms.
It's true. And finally, the most important thing, especially for the in-your-car part, please be safe when you're driving. Focus on the road.
Yes. Please don't cause a tort while listening to torts.
Huh? It's a good one. Always relevant.
Just quickly, the contact info again for podcast questions for Angela. It's podcast@studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk help, research, writing, AI consulting, it's hello@legalwriterandlawclerk.com.
All right. Tradition dictates.
Oh boy, here we go. The lawyer joke. Lay it on us.
Okay. Why did the lawyer bring a ladder to court?
A ladder. I don't know. Why?
Because they heard the case was going to be elevated to a higher court.
Oh, elevated. Okay, that's painfully plenty. I'll allow it.
This is Claude and Maud, your AI bots signing off.
Thanks for listening, everyone. Bye. Keep up the great work.